Good afternoon.
Good afternoon, Your Honor. I would like to reserve 5 minutes for you.
5 minutes, yes, sir.
May it please the court, my name is Jimmy Meeks. I'm counsel for appellant defendant Vastland. And the matter before the court involved a real estate contract and a contract dispute over 2 townhomes in the same building of a large real estate development. And I would like to focus my oral argument here on what I had posited was kind of the core issue in this case, in which all the errors, the alleged errors from the trial court hinges, which is which party exhibited the lack of good faith in getting to the closing table here. And I think the preponderance of the evidence was clearly...
Does that matter since one party has now purchased the property?
Yes, Your Honor. So the decree of specific performance was complied with, and to the extent that that decree was found to have been issued in error, I think there's still relief that the trial court as a court of equity could afford the parties here, specifically Vastland, which is, one, awarding us the attorney's fees under the contract for have been in the prevailing party under that contract dispute. And then also holding and accounting for, okay, well, we transferred this property on this date, July of last year, and the contract price was entered in July of 2021. So the difference in the fair market value of the property at the time that it was transferred versus the contract price, of further accounting for any rental income that might have been gained at the property while it's been in the ownership of Mr. Lublin, while any maintenance and used property taxes, the court could still afford relief here if the decree of specific performance is found to be in error. So going to one of the first primary errors of assignments of errors on the trial court was, does the preponderance of the evidence here at trial show that Mr. Lublin was actually the one who committed the first material breach? Now, the trial court found that it was in a phone call between Ms. Senabaldi, Vastland's broker, and Mr. Lublin's attorneys after we had sent the cancellation forms. That was the first breach in this case, with Vastland breaching by failing or refusing to close. So then the question is, did Mr. Lublin commit a material breach before that date? And Vastland argues that yes, he did, because he did not close on April 29, as the parties had, it's just not in dispute in the trial court record. Mr. Lublin even admitted in his complaint that he was coming in on April 29 to close the properties. So was this failure to close on April 29 a material breach? Trial court, all the parties are in agreement that generally speaking, the obligation to close a real estate contract is not a material breach unless time is of the essence for that obligation under the contract. So was there language in our contract that rendered time of the essence for closing? And yes, our contract, the language of our contract.
There's no specific language that says time is of the essence, though, right?
Yes, Your Honor. So the complaint had language, the contract provided on page 4, if the buyer is in default, the seller may, without notice, sell the subject house and real estate to others. And just one paragraph before that, it provides, if the buyer fails to pay the balance due at closing or fails to comply with any other terms of this agreement, it shall constitute a default. So default is defined as failure to comply with any term. And then the remedy for default, if the buyer's in default, the seller may, without notice, sell the subject house and real estate to others. So that language renders time is of the essence for every obligation. If failure to comply with any obligation rendered the buyer in default, and one of the remedies available to the seller for any default was you can sell it to other, logically that requires cancellation of the contract. You can't sell to anyone else without canceling that contract. So time was of the essence for every contractual obligation of Mr. Lublin under this contract.
How do you get, I'm sorry, I'm having a little trouble getting time is of the essence out of those provisions.
So the Cry Lake case that we rely on specifically found that in that case, the contract didn't have the term time is of the essence. It was another real estate contract. But the contract did say if the seller fails to perform at closing or fails to close on this date, then or if the buyer fails to close on this date, then the seller shall have the right to cancel the contract. And the court found that to render the closing obligation, time is of the essence for the closing obligation. So the Cry Lake court found if the seller has the right to cancel the contract for failing to comply with an obligation, time is of the essence for that obligation, even if the words time is of the essence verbatim is not in the contract. So what we have here is a contract that gives us the right to cancel and go sell to anybody else we want for failing to comply with any term, let alone the closing
Am I
obligation.
mistaken, or is there a $75 provision here related to delay and timing? And am I misunderstanding? How does the $75 provision fit into your argument here?
So it provides that, yes, in the event the buyer fails to complete the home within 5 days of substantial completion, then it has this $75 a day penalty. But it clearly shows that it's a failure to close within 5 days of substantial completion. It says if the buyer fails to do so. And then in that same paragraph, it then says if the buyer fails to pay the balance due at closing or fails to comply with any other term of this agreement, it shall constitute a default. So it still says, regardless of this option to take $75 a day if the closing does not occur within 5 days of substantial completion, it nonetheless says if the buyer fails to pay the balance due at closing, then it constitutes a default. So then, was Mr. Lublin obligated to close the contract, and on what date was he in breach? Vastland argues that that date was April 29. Mr. Lublin's theme throughout his case at trial accounted no less than 20 times in the transcript where he testified, well, I was never given the opportunity to close these contracts, but as we pretty thoroughly lay out in our brief, he was given multiple opportunities to close. And Vastland's not arguing that each one of those opportunities that he declined to close was a breach. We are arguing that it was the April 29 opportunity to close that he clearly tried to delay so that he could go get financing from a new lender, when on April 26, everyone learns that the only lender he had applied with had denied his loan application. So on April 17 or April 18, Mr. Copeland, Mr. Lublin's agent, asks Ms. Tippett, Vastland's agent, when he should tell Mr. Lublin to close or to fly in to close. Ms. Tippett responds, "You can close anytime." And then Mr. Copeland declined that offer because, well, parking lot issues. He didn't want to close because of the parking lot. But regardless,
he could close at any time with a list of things that still had to be corrected, right? And
Correct.
he didn't want to do it that way.
correct. And that was on April 17 or 18. We're not saying that it was a breach for him not to close then. But these parking lot issues are then resolved on April 21. And this is relayed to Mr. Lublin that, oh, it's all done now. Your parking lot's clear. We're good to go. And Mr. Lublin's response to that was not, well, I don't know if the units are done. It's not. And this is in his text to Mr. Copeland. His response is, well, I should have funding, and I don't. So then the parties, on April 21, there's clearly text between Ms. Tippett and Mr. Copeland, confirms everything is done. We're ready to go. Mr. Copeland texts to Mr. Lublin that this is ready to go. He alleges in his complaint, okay, April 29, we're closing. Ms. Tippett texts to confirm that with Mr. Copeland. And then April 26, everything kind of blows up because the lender denied the financing. But Mr. Lublin had no right to then try to delay that April 29 closing to then try to go get new lending from a different lender. And then the text
Was
between
the
Mr.
April 29 closing a definite date? The trial court treated all these dates as just tentative was the word I believe the court used.
So the only extent to which it would be tentative would be closing. Parties testified closing was this, between the buyer and the seller and the closing agent. Everyone kind of works together to make sure they have everything. But if Mr.
And
Copeland,
there was a lot of confusion, right? I mean, that's what the trial court found.
I don't think there was any confusion after April 21. The only confusion anywhere in the record of anything after April 21 is Mr. Lublin didn't have a loan. But he had testified he could have closed the day after the contract was signed, wrote a check, closed in cash, and he could have closed. The only reason, and Mr. Lublin at trial in the briefs never provides any explanation why he didn't come and close on April 29, other than he wanted to not close in cash and go get new financing from a different lender. But his obligations to close weren't contingent upon financing. He had an obligation to close on April 29 in cash. That was the only way he could have complied with his loan obligations. If Mr. Copeland's testimony was, if closing was not technically scheduled because Mr. Copeland had never told this title company, yep, here's my closing package, I'll be there on this date, then under that theory of the case, he could have delayed closing indefinitely simply by not giving the title company what they needed to close. The parties had clearly said April 29, coming in to close. The only reason he didn't was because his loan went through and he tried to get new financing from another lender.
All right, thank you, Mr. Meeks. We'll hear from you on rebuttal. Mr. Seaman?
Good afternoon, Your Honors.
Is any part of this moot?
Yes, Your Honor.
Which part?
The breach of contract claim that they are now making for the first time on appeal. At no time during this entire case has Vastland ever affirmatively made a breach of contract claim. In fact, on July 2nd, 2022, when Vastland filed their original answer, they filed a counterclaim for a declaratory judgment to void the contract. At that time, they could have absolutely 100% said, we aren't in breach of this contract, Mr. Lublin is in breach of this contract. They didn't do that. They asked the court to declare the contract was void, and they asked for it for reasons that ultimately the trial court found were not credible at all, for price increases that the trial court found
Speculative.
It was very speculative on the price increases. The other thing, what happened later, about 2 months before trial, Vastland moved to amend their answer. They dropped the counterclaim, filed a motion, or they dropped the counterclaim, added an affirmative defense that Mr. Lublin was the first to materially breach. But that's an affirmative defense. They didn't ask for any relief, and that's one of the primary problems we have is the practical downstream implications if this court were to somehow, first of all, we don't believe that the breach of contract was an error by the trial court, but let's assume for a second the court was to reverse that ruling. What's going to happen now? These properties have sold. There's nothing in the record to even say whether Mr. Lublin even still owns these units. We don't know if there's third-party tenants. That's just going to cause chaos. Well, so I think what they'd say is, well, we're not really seeking for the court to unwind that transaction. We're okay that we sold it, but what we should have is breach of contract damages that we should be entitled to of the difference in the contract price and the fair market value. Well, that exceeds the scope of appeal. That was never, this is Black versus Blount case, that was never raised below. They had every right, if they believed that this contract was materially breached, which they're arguing by Mr. Lublin, they could have brought that up immediately in their answer, their first answer, or at minimum in the answer that they amended 2 months before trial.
Did they ever ask for a stay or anything to not go ahead and sell the property?
They did not. And under Rule 6205 and 6204 and 6205, they didn't ask for a stay. They could have absolutely 100% gotten a stay. They could have posted a bond. They did not. The bond 6205 specifically speaks to the bonds and the amount it would be when you're talking about a judgment for selling property, and it's going to involve the costs of not conveying that property. And in fact, I believe the reason they didn't seek a stay was because they wanted to cut off potentially any of the damages that we've alleged in our cross appeal related to the mortgage-related damages, but more importantly, actually wanting to cut off the fair rental value that the trial court did not award our client.
Counsel, with regard to the TCPA issue, the cause and confusion or misunderstanding with respect to the authority of salesperson, representative, or agent to negotiate the final terms of a consumer transaction, is that limited to the representations from Ms. Tippett?
No. The opposing counsel, first of all, this specific section, subsection 14, I've researched, I know the other side has as well. I've only seen maybe 8 cases in Tennessee that even cite this provision, and they make the argument based on the Thomas versus Share Laboratories that the confusion, and I want to be clear, it's not just confusion or misunderstanding. They make the argument that it has to be generated from the principal making a confusing statement about the agent. That is not what Thomas versus Shire Laboratories says, and of course it's discussing it in a different context than this. What happens in that Thomas case is the representations that were being made were made by an agent who had no authority at all to speak on behalf of the alleged principal. There was no designation of agency. So it'd be similar to us going to buy this property and a homeless person comes up and said, hey, I've got authority to sell you this house. I'm going to sell you this house. Well, obviously, you can't hold Vastland liable for a confusion when that person never had any authority to speak. But that's not the case here. Here, Ms. Tippett.
How did this confusion or misunderstanding with respect to authority of salesperson, representative, or agent or negotiate the final terms of consumer transaction, how did that cause an ascertainable loss of money, property, real or personal, mixed, or any other article, commodity, or thing of value, whether situated? It doesn't seem like there's any reliance here on the representations. I'm struggling to see what the actual injury is, the loss is.
So the trial court specifically found that Mr. Lublin, through his agent Brian Copeland, reasonably relied on the text message exchanges on April 27th and May 1 by Beth Tippett, saying, in essence, we don't know who the they really is, we believe it's Mac McClung, who's also an agent, is requiring me to send you cancellation forms, but ignore it until you decide, Mr. Lublin, whether you're going the cash route.
And what's his loss?
His loss is the real property. But for this lawsuit, he's not getting the property. So I think one of the arguments they make is about, well, proximate cause. How is this the proximate cause? Well, I think this is a situation where both the TCPA and the breach of contract claim, the remedy and what we were seeking was the property, specific performance. The court awarded it in the specific performance. We obviously can't get the same remedy in the TCPA, but it doesn't mean that we couldn't bring both legal theories for the same relief, but under the election of remedies, we can't get both recovery. The TCPA specifically says the ascertainable loss can be property. And the ascertainable loss here was the confusion that was caused up until we get the order from the judges. We were deprived of the property that we had contracted for. So we did not get that property. I think it's important to understand, Mr. Meeks made the point about, well, this is a good faith and bad faith situation. Well, I think the good faith and the bad faith plays into both causes of action. Obviously, the implied duty of good faith in contracts, we have to look at that. I think what's a little disingenuous, though, is the allegation that they've raised that the only party that acted in good faith was really Vastland and not Mr. Lublin. Well, that is completely contrary to the facts, the evidence that came in. Tamara Sinibaldi was the managing broker for Vastland. Beth Tippett was the designated real estate agent for Vastland. They both testified that it was Mr. Lublin who acted in good faith, and the implication from their testimony was Vastland was the one that acted in bad faith. Brian Copeland, the real estate agent for Mr. Lublin, who I would actually argue is really an independent witness because he had a financial incentive to continue working and selling Vastland's product. He even said that. He said this was bad faith, atrocious conduct in the worst way. And he was trying to sell Vastland's products. He made money off that, but he still felt inclined to say that, and the trial court, in closing, even accredited his testimony. And the reason it applies to the TCPA is 4718-1024, the policy behind the Tennessee Consumer Protection Act. Broad remedial purpose, liberally construed. Subsection 4 of that, to declare and provide for civil legal means for maintaining ethical standards of dealing between persons engaged in the business and the consuming public, to the end that good faith dealings between buyers and sellers at all levels of commerce be had in this state. So that's exactly what happened. If Vastland would have just closed this, and Your Honor, there was no evidence of a closing. If they had just closed it, we wouldn't be here, obviously, on a breach of contract or the TCPA.
Well, they said that they wanted to close it on the 29th, and Mr. Lublin wouldn't. Would you address what he said about that?
Absolutely, Your Honor. So they've made a big deal about a lot of alleged opportunities to close. The issue with really, Ms. Tippett, they put in their brief, it was either the 28th or the 29th they were offering to close. This doesn't make any sense if they are literally scheduling a closing for that date, because the day before, on April 27th, Ms. Tippett is sending a text message to Mr. Lublin's agent saying, we are canceling this deal. They are sending me forms to cancel this deal. How can they say there's a closing scheduled for April 28th or 29th when they're also saying we want to cancel this deal, that Ms. Tippett then says, just ignore it anyways?
Okay, the 27th, the forms were sent.
The forms were not sent on the 27th.
Okay.
The forms were not sent until May the 1st, Sunday night,
Okay.
May the 1st.
They were discussing the forms.
Correct. They were discussing them. The record was Ms. Tippett and Ms. Sinibaldi were still trying to work on the forms. We have obviously put in the briefs that those forms in the trial court held didn't legally cancel the deal. It was a notification form, and really it was a release form saying, we'll release you from any liability if you release us, and we'll give you the earnest money back. But they were still intending to try to cancel it the day before they're saying, well, we've given them a closing date on April 28th or 29th. And I think on the closing date, what is important is the Hilliard case we cited. That basically says if no closing is scheduled, then there can't be a breach on behalf of the plaintiff, on behalf of the buyer. I do want to, if I can, switch gears to my cross appeal on the mortgage-related damages and the fair rental value. With regard to the mortgage-related damages, the trial court, I think it's important to understand the distinction between damages. If there's an uncertainty as to the fact of damages, then that's something that a court cannot award damages. If there's not uncertainty as to the fact, but there's some uncertainty or an estimate or imprecision as to the amount, a judge can still award damages. Here, the trial court found the fact of damages was established. The trial court specifically found Mr. Lublin suffered substantial monetary damages. And then as to the amount of the mortgage-related damages, between 4.5% and 8.5%, that was the 2 years the mortgage interest rates had obviously gone up, the court found the amount that Mr. Lublin testified to was accurate. What the court did was assumed. The court assumed that Mr. Lublin was not going to actually finance these, that he was going to close this in cash. Well, that was contrary, first of all, to the evidence. Mr. Lublin testified that he was always capable of closing in cash, and if they required him to come that minute and sign, he would have done it in cash. But his intention, he said, was always to close with financing, and even if he had closed in cash, he would have immediately financed these at the same rate. So the damages, the fact was established, the court assumed that he would close in cash, didn't award it, and we believe that was error and that should be awarded. As to the fair rental value, this is a situation where I believe there are two Tennessee cases that are directly on point on this, Bush versus Cathy, and then Smith versus Smith, the case that Judge Clement and Judge Bennett, you both were authoring that opinion. Those deal specifically with an award of lost rental value incidental to an award of specific performance. The other side has cited cases saying, well, these are lost profits. These are just akin to lost profits, and the burden of proof is on the person seeking lost profits to prove up their offsets, their expenses, their overhead. Well, first of all, none of the cases cited by Vastland have anything to do with specific performance. The law in Tennessee is when there's a breach of contract and there's damages, offsets, mitigation must be proved by the party seeking it. Vastland, for reasons I don't know, didn't put on any proof with regard to any of offsets. But I think more importantly of why this couldn't be categorized as lost profits. In a lost profit case, the person that's seeking the profits obviously has a history of their own overhead and expenses that they can come forward, put evidence on. Mr. Lublin had never owned these properties. He has no evidence of the expenses, the property taxes, the homeowner's insurance. And then the other area, and in the Bush versus Cathy case, that's the very thing the court reversed on and remanded, because what happened in that case, the court actually awarded fair rental value, but said, you know what, I know there's some cost in owning a home, so I'm going to reduce that on my own. Well, there was no evidence of offsets here, and yet the court did the same thing. I believe the offsets would outweigh the amount of lost rental income. Again, the court found that the amount, the 101 in lost rental income for the 26 months was accurate, but found that it was going to be offset by evidence that was never there.
So should we remand it for a hearing on that?
I don't believe so, Your Honor. I believe that we actually had, one of the arguments we talk about is an alternative of sending it back for an accounting, but I believe actually, and I said this in the closing argument, that that's what we were doing there. We were going ahead and putting forth the proof of the lost rental value, and it was incumbent on the defendant to come forward with the offsets. But if Your Honors disagreed, I think at a minimum, it would have to be remanded for an additional hearing, which is exactly what happened in the Smith case. It was remanded, an accounting hearing was had where both parties got to put forth evidence, because we also have the issue of the interest rate. The Bush versus Cathy talks about interest being awarded to the seller for the time they would have had the purchase money. The problem is the trial court, again, just assumed we're going to use the prejudgment interest standard. Well, Bush versus Cathy doesn't say that. Bush versus Cathy says it'd be the appropriate interest rate, and there was no discussion by either party of the appropriate interest rate. I see I'm out of time, Your Honor. Thank you.
All right. Thank you, Mr. Seaman. Mr. Meeks, your rebuttal.
Yes, Your Honor. So on this mootness issue, it was mentioned we never had a claim for breach of contract. Well, we're not seeking damages here for breach of contract. We're seeking damages for the erroneous decree of specific performance, which we obviously could not have pled in the underlying court because we had not had that decree. And there'd be no need to set aside, counsel correctly stated, there's nothing before the court about the current status of the property tenants, you know, if Mr. Lublin had even sold the property. But that is irrelevant to whether or not the court can adjust the accounts for the way that Vastland was damaged for the erroneous decree. Going to what counsel had stated, Mr. Seaman had stated about the damages issue, ultimately what the court found on damages was that Mr. Lublin had not provided any sufficient evidence to prove any damages beyond speculation. So even if this equitable accounting is what had happened at the trial court found, for instance, on the mortgage-related damages, that there was no evidence other than Mr. Lublin's testimony of his understanding of what his rate would have been or what he was offered, that there was no evidence of a final rate. The court simply found that there was no basis to award such damages.
Well, could we send it back for a hearing to develop that evidence?
Well, I think that would be giving Mr. Lublin another bite at the apple to prove his damages, having insufficiently done so in the lower court. And on the lost rental income, the court found in its post-judgment ruling on the 5904 motion, the court didn't actually find the rental value being 1950. The court said, hypothetically, if I were to award the rental value, that she would find this. If she were to award the lost rent, but the court declined to award the lost rent, I would posit that that was dicta, not actually a finding of what the court had said in the judgment, in her original judgment, that there was nothing beyond speculation as to what the rental amount would be, what the occupancy rate would be, et cetera, that the court would need to arrive at a reasonable estimate of the fair rental value. To discuss the TCPA issues briefly, there was no actual confusion here. The court found that the confusion was about Ms. Tippett's authority. Even if the ignore it text that she had sent and these cancellation forms, even if there was confusion about that, or I think the evidence clearly showed that there was no actual confusion. When Mr. Copeland receives this text from Ms. Tippett saying to ignore it, he relays this information to Mr. Copeland, or to Mr. Lublin. Nowhere in his text does it say, well, she's telling us to ignore it. I don't really know what that means. What he says to Mr. Lublin is, just got off the phone with the buyer's agent. They're requiring that she send the cancellation forms. In the timeline that Mr. Copeland provided to Mr. Lublin's attorneys, just a few days after the contract dispute had kind of blown up, in his timeline about that text, he never says, well, I was kind of confused about this text where she says to ignore it, but then we get these cancellation forms. I don't know what she's talking about. And that's because he knew exactly what was going on. He had already texted Mr. Lublin. Beth is hiding out from Vastland. She's on our side in this. When asked at trial about that text, Mr. Copeland was confronted with his deposition testimony where he said, oh, I don't really know what I meant by that about her hiding out. And then at trial, he had said, well, that really troubled me at my deposition. And then he testified, she is frustrated. She wants to close. She knows that we can't close with financing there if Mr. Lublin could close in cash. And she wants to do the right thing. As I said, there was hiding out. She was trying to get to the closing table with us. So I think that shows clearly there was no actual confusion. They knew that Vastland intended to cancel the contracts unless, as Ms. Tippett put in her timeline that she submitted to Vastland, she had told them unless he closes immediately with cash or a margin loan, they intended to cancel. That was on April 27. His only obligation there was to then come on April 29, close in cash immediately. If he wanted to refinance with this alleged financing offer he had from First Bank that was going to take 2 weeks to actually close, he could have done that. But he had to close with cash immediately on April 27 when the private communications clearly show they knew exactly what was going on. And I'm out of time.
All right. Thank you, Mr. Meeks and Mr. Seaman, for your arguments. We'll take this matter under advisement. That concludes the afternoon docket.